Hey guys, another lecture here. This one's going to be going over medical, legal, and ethics in EMS. Basically, fundamental knowledge of the EMS system, all the medical, legal, mumbo-jumbo stuff that can keep you out of jail, stuff you don't want to do, stuff you need to do, all the legal stuff to keep your patient safe and yourself safe. Also going to go over legal, ethical issues to the provision of emergency care. A lot of people find the med-legal part of medicine absolutely boring. It is very important, and you're going to use it for the rest of your career. You're going to know these terms for the rest of your life. Hopefully you take this stuff home. You're able to utilize this stuff in future settings to help family members out and friends out when you see any wrongdoing. We're basically going to be covering the different types of consent, as well as obligations that you have and complications that you might find. We're going to cover the mandatory reporting. As an EMS provider, you are part of the mandatory reporting group. So if you see something, you are required by law to say something, and we're going to go over which of those somethings you're going to have to report. We're going to cover advanced directives, also known as DNRs in a lot of common places. We're going to cover torts and criminal actions. These are more trials, jury type things, and in front of a judge. So we're going to cover some of that information. Evidence preservation, what our obligations are at a scene, what kind of scenes we're looking at, and then we're going to cover ethics and summarize at the end. So hopefully you guys enjoy. Every single patient requires consent before treatment can occur. This can be written consent, verbalized, or even implied. Consent requires knowledge of the illness, the treatment options, risk, and any alternatives. This is the information that the patient will need to know before any treatment can be refused, and this must be initiated before treatment can be started. So they need to know what it is that's wrong with them. Sure, your arm is broken, can we splint it? You go in and have a surgery, the doctor's going to come by and tell you what's going on so you know what you're having the surgery for. How is it treated? With a splint, with a surgery. The patient, in any time you've been treated with things, you need to know what it is and how it's treated. They're also going to tell you the recommendations. You need to tell the patient what you recommend. So your arm looks broken. I think you need a splint. This is what you're going to do. You're going to have to cast it. They're going to need to know the risks. If you splint somebody's arm, maybe you put the splint on too tight, they can develop clots. There's all sorts of risks that are involved with a lot of treatments. This could be as simple as checking a blood pressure and say, hey, I'm going to check your blood pressure, or I'm going to assess you and I need to check your blood pressure. Some of the complications that can come with this. 90% of the time people don't really question it beyond, hey, can I take your blood pressure? What are some alternatives? If somebody doesn't want a medication, what is something else they can try? Having a doctor prescribe like an opiate. I had a broken shoulder and I told him I don't want a narcotic drug. I actually had to ask for the alternative, and what he could have done was actually offer me different alternatives to the management. And so I gave consent, but it was after we talked about other things. So think about anytime you've had interactions with medical people and how they've explained to you like things you've had to sign, kind of how redundant it is, because the nurse will come in and say something and the doctor will come in and say the same thing, and you feel like you keep having to give consent over and over. But that's why. They need to make sure that you know what you're getting into so they don't get sued. So we talked about like the purpose of consent. We need to talk about the different types. So I said before, it can be written, it can be verbalized. That's basically expressed. Nodding your head is a nonverbal expression. If I ask you and you nod or you shake your head no, that's telling me yes or no without actually using words. Informed consent is telling them all those things. What's going on? How you're going to fix it? What are the risks? What are the benefits of it? So when you get into implied consent, they can be incapacitated physically or mentally. So a child is conscious, alert, and oriented, but they are not at the capacity to make decisions for themselves. And we would assume that their parents would want us to take care of them. So it's implied. 3-year-old kid, scrape on his forehead from a fall, parents aren't around. We're going to go under the assumption that his kid's going to want to be taken care of by the parents. You find somebody that is unconscious on the ground, they can't give you any consent. They can't say, hey, can you help me? You can't inform them of everything. But there's this idea that you would assume that any person that was unconscious would want some sort of help. And then there's involuntary. It doesn't matter if they say yes, no, maybe so, anything. They have done something that has made them unable to express their consent by either a mental health issue, whether they're incarcerated or under the custody of another. What I mean like mental health, if they're having a psychotic episode, psychosis, other behavioral problem, like suicidal patients. Suicide is not a normal, people don't want to die. So if somebody's suicidal, they no longer have the ability to take care of themselves. They have been placed in the care of the trooper, the police officer, EMS. They're no longer able to refuse treatment, but you have to document the heck out of this to state why they were taken against their will. And it can be legally done if they are incapacitated some way, whether it's mental health or incarceration. If you don't do the right documentation, another thing that is defined by taking somebody against their will is kidnapping. So you definitely do not want to be charged with kidnapping. So make sure you document expressed that you informed them, or that it was implied consent, or that they did not have a choice and it was involuntary. So what do we think about each one of these? A couple different ages, different abilities. You got a 16-year-old male skateboarding around, broke his arm. Can he consent? Can he refuse? 16-year-old, unless they can provide evidence they've been emancipated, it is implied that the parents would want the care rendered. 54-year-old female, she smells of alcohol, she's unable to answer questions about herself, and there's a large cut on her forehead. Is she able to refuse? Is she like, no, don't touch my forehead? Is she able to consent to treatment? So the 54-year-old could not ascertain the appropriate safety questions. And then she is, what they call in the state here, Title 47. She's unable to refuse due to the inability to recognize dangers of life or health. 21-year-old male, suicidal threats. 21-year-old behavioral male, unable to ensure life and limb safety, involuntary consent. Unconscious female, unknown medical history. You're walking along, boom, there she is on the sidewalk. This is implied for unconscious. We assume people would want to have care rendered. What would happen if we were not informed of risks and refused care and then injury, illness worsened? So we tell somebody that, all right, you don't want to go, fine. But we don't document that they were informed. They can always come back on us and say that they didn't know why, they just refused, and then they can come back as saying that we abandoned them. So before we kidnapped them, and now we didn't give them give them enough information for them to adequately refuse, and instead we abandon them without care. So we covered two of the definitions without actually using the words. So abandonment, we kind of saw how that is. We abandon them without another level provider caring for them before they refused. False imprisonment, also known as kidnapping. Assault and battery. Think about the two different things here. Many times they're combined. Person convicted of assault and battery. They're actually different. Assault is a threat, a physical threat, like without the actual contact, a threat of danger to life and limb. I'm going to punch you, or I'm going to start an IV on you, or anything where I'm going to do something to you and you're not going to like it. That is assault. Battery is the physical touch. I don't ask for your permission and I go ahead and slap a blood pressure cuff on you. I have committed battery. So the physical touch. How I like to think of it when I was an EMT1 was, I throw a grain of salt at you. It's not going to touch you. It's not going to hurt. Assault. If I chuck a battery at you, it's probably going to hurt. Battery. So you can think of different ways to remember those. That's the best way to do it. So abandonment, you don't get the right refusal. You don't give them the appropriate care. False imprisonment, you kidnap them against their own will. Assault, you shake a little salt here and there. You don't really hurt them, but it's still bad. And that AA battery is right between the eyes. So those are the legal obligations and complications that can come with how you're reacting with your medication and your levels of consent. Confidentiality in the healthcare setting is covered under HIPPA, which stands for Health Insurance Portability and Accountability Act of 1996. Essentially, HIPAA is to improve efficiency and effectiveness of the healthcare system by standardizing administrative and financial data exchange. Basically, it gives patients more control of their data. They know when their information is being sent and where it's being sent to, whether it's to other healthcare professionals or it's to insurance company. HIPAA also sets boundaries for uses and disclosures of this patient health data, and it establishes different safeguards to protect the patient. It establishes accountability for any breaches of the privacy. What helps out with HIPAA is the OMNIBUS rule. It was passed in 2013, and it's designed to incorporate the provisions of health information technology for economic and clinical health. It's any genetic information as well as computerized information. You can see here the different levels of laws. At the federal level, it's enforced by Health and Human Services Office for Civil Rights. States and local authorities impose stricter laws on HIPAA, but they must meet the federal HIPAA requirements at a very minimum. And EMS agencies need to be aware of and comply with the state, local, or any other, like if your company has, like we don't use cell phones, we don't want pictures being taken here. And it could be different at different services, whether they've got like a Tiger Text phone or other electronic recording device. To be able to send information that is not secured or to non-medical or HIPAA locations, we must de-identify the information. Not all information is considered PHI or protected health information. All key identifiers have to be removed so the person can no longer be identified. That's only in cases where you're sending it to non-medical personnel. Otherwise, everything is allowed to be in there. It just needs to have permission and accountability for it and to be secured. Here is a list of all the identifiers. These are things that are personal to people and that cannot be shared or made public. You take a look here, and some people wouldn't understand why some of these numbers, locations, names, any of those things would be considered protected or identifying, but even a license plate and a picture of an accident scene, people can look up that license plate, that VIN number, find out who the registered owner is, and then boom, they've got an ID of who was involved in an accident. Dates, only when directly related to an individual. So an incident date, date of birth, or date of death. People can look up those specific dates. So you're talking about a person that has a shoulder injury, and then you give a date. Somebody may be able to look up that date and injuries in a log and find out exactly what patient you are talking about. There really are no excuses to breach confidentiality. Ensure that only appropriate people are given access to the PHI. You don't need to be telling coworkers and friends about calls that you've been on. Definitely don't take any patient care reports home. If you need to work on them later, keep them in a locked cabinet in the office. You're going to need to shred any unnecessary paperwork for, like when we do notes and you write things down on a piece of paper, their demographics and a set of vitals. And definitely no gossiping or rumors. Breach of confidentiality. Here is where you can actually speak a truth or non-truth outside of what your legal boundary is. So there's actually a difference. So libel and slander are part of the breach of confidentiality, but it's also defamation of character. So you break that confidential code, you can be found with defamation of character as well. So libel is the actual written bad things about you that are untruths or defaming their character, essentially. Slander is the spoken. So if you think of libel like a pen, the L being a pen or pencil, and slander being the S in speech or spoken. So I say some bad stuff about you. You can find me having slanderous behavior. If I write an article about you, saying bad things about you and all these lies, I can be found with libel. How these weird National Enquirers kind of get away with it is they say from an anonymous source, and what they thought was absolutely true because of their anonymous source, they didn't think it was a lie. So that's how they get away with libel and slander, because quote unquote an anonymous source told them some good information. So that's one thing if you want to consider how much you believe anything that's written with an anonymous source. As I said before, with mandatory reporting, once you're in the EMS system, you have an obligation to report. Anybody in the school district, bus drivers, teachers, anything like that are in the mandatory reporting. Anybody in the healthcare community is also part of mandatory reporting. So in order to protect children whose health and well-being may be adversely affected through non-accidental means of harm, physical injury, neglect, mental injury, sexual abuse, sexual exploitation, or maltreatment, it is required that practitioners of the healing arts and others make reports of these so then they can be investigated and dealt with before they get worse. So it's basically to speak up for those unable to speak up for themselves. So one of the mandatory reports is the subject is going to be a child, basically anybody that's under the age of 18. Child abuse or neglect means physical injury or neglect, mental injury, sexual abuse, sexual exploitation or maltreatment of anybody under the age of 18. So physical injury, actual physical pain, neglect, it could be emotional neglect. There's a couple different variations of neglect. Mental injury, so they're calling names to the kid. Sexual abuse and sexual exploitation. Now these are different. Sexual abuse, the physical touching, molestation. Sexual exploitation, kiddie porn. So they're being exploited, but they're not actually being physically contacted or touched. Maltreatment means an act or an omission that results in circumstances which there's reasonable cause to suspect that a child may be in need of aid. So anybody under age of 18, any of these type of injuries, neglect, needs to be reported to the state. And anybody can commit these. So it could be a parent, it could be a custodian, it could be a guardian, it could be a stranger, a neighbor. It doesn't have to be a specific person that is causing these issues. It is our responsibility to report them. You guys are welcome to text me or email me, ask me any questions about more information about these, but you should definitely look into these definitions and know them, know the difference between the physical injury, the mental injury, know the difference between abuse and exploitation. It's not just kiddie porn, it's being a pimp and making the child be a prostitute. Any of those things is part of that sexual exploitation. The damage is being done not physically by that perpetrator. So children under 18, then we go to the other end of the spectrum, the vulnerable adults. Depending on their age, there's no magic number. It's really dependent on their situation, mental, socioeconomic status. We need to protect them from abandonment, exploitation, and it's not kiddie porn. I mean, it could be. There's people out there that are into grandma porn. Really, it's exploiting them for other things, convincing them to donate money to the Nigerian prince, or, hey, grandma, I need you to sign this piece of paper. Don't worry, don't read it, and then it ends up being a contract for something, or signing over a check for something. So that would be the exploitation of a vulnerable adult. Abuse could be that physical abuse, mental abuse, neglect, not giving them food, water, not taking care of them. And then there's actually self-neglect. So they can't take care of themselves. They're unable to change their own clothes, and they want to stay in their home, but it's dangerous and they keep falling. They're unable to provide their own food. They can't pay their bills to where they have heat and they've got 15 blankets on, but it's still freezing in the house. These need to be reported. I know that grandma wants to stay in her house, or grandpa. They want to stay in their home and have the independence, but it's a danger to themselves. So you have to report the self-neglect sometimes. So like I said, it kind of depends on their mentation of what makes them vulnerable. I mean, it could be as low as 18. They've aged out of the child protection and now they're in the vulnerable adult. It could be somebody that's disabled, somebody that's ill, chronic illness, inability to comprehend things. Any of these, abandonment, exploitation, abuse, neglect, or even self-neglect, needs to be reported within 24 hours after the first case that you believe that there's an issue. It needs to be reported and referred for vulnerable adult safety. So when you make a report, you need as much information in there as you can. A lot of people have similar names. Some people might have the same name, same birthday. There's a lot of Esquires and Juniors and the thirds out there. So you need to make sure you get as much information as you can. This slide here specifically talks about children, but you can use this for any report that you're doing, so adult or child. You need the name, address of the child, the parents, basically anybody that's responsible for the child or the adult, the age and sex of the person. Again, there could be similar names. You need to report your belief of the nature and extent of the harm, what is going on. You also need to give the information of who it is you think is responsible for the abuse. So it's nephew Jimmy Joe and he's 34. You need to put that information in as best as you can. If you don't know, you can't make stuff up. You just gotta put what you know. Any information that you think will be helpful in establishing who this is and what's going on. So the more the merrier. Get as much out there as you can. If you can't remember the definitions of things, write it out like a story. You saw this child, these bruises and a dog food dish for a plate, like, I don't know, bizarre stuff. Just put that kind of stuff in the report. What can protect you when you are doing mandatory reporting is immunity. As long as you make a report in good faith, you believe that there is a concern. You can be wrong, you can be right, but if you truly believe that there is something wrong and you report it, you are immune from civil and criminal lawsuit. If it is done in a timely manner. If you wait until there's already an investigation and then you come up and say, oh yeah, I remember this case, I'm reporting it now, it is too late and you can be found liable. With these here, good faith reporting in a timely manner, you cannot be held criminally or civilly accountable for these actions. If you fail to report, it could be a Class B misdemeanor. You could lose your medical license or your certificate, and now you're liable for civil lawsuits. So you didn't say anything when Timmy went to the hospital and the stepfather was doing something horrible to the kid. And now the biological father is going to sue you because you didn't say anything, you didn't report it. So now you're liable to be criminally charged as well as civilly charged with whatever they deem. So just notifying your supervisor or your medical director is not sufficient. You must comply with reporting requirements. There is actually a few ways that you can report depending on what the situation is. Making the phone report, making the online report, tell a trooper on scene, and then make a report anyways. If there's 2 people in your crew, both of you need to report, because you can't just assume, well, I don't need to make it, they did it, and now nobody's done it. So get 2 reports done, 3 reports done, it doesn't matter. The more reports they have, the more ground they have to do their investigation, the more information. Maybe your story is a little bit different and they got the best information out of both reports. So it is not good enough to just tell a passing person at the hospital. You need to make an official report. So it's not just the people that need to be reported about. There's actually specific injuries that need to be reported. The following injuries, according to state of Alaska, 2nd or 3rd degree burns to 5% or more of the patient's body, and any burn to the upper respiratory tract or any laryngeal edema due to the inhalation of superheated air. So don't think of this as reporting a crime. We are reporting significant injuries, so 2nd or 3rd degree burns, 5% of the body or more, and any inhalation burns. These are significant wounds. We need this for statistics on our state. Fire prevention, fire like funding, burn centers, anything like that. It gives us information about what's going on in our state and what resources that we have. This is not 1st degree burn. Hell, you get a wicked sunburn, you can have a 1st degree burn over your entire body. 2nd degree burns going to be a lot more significant. Third-degree burns are going to be your full thickness burns. Now, 5% of your body is not a whole lot in percentage-wise, but when you're thinking about that level of depth in the burn, we're looking at a huge amount of tissue. Now, 5% is your hand. So the patient's hand, the child's hand, that is 1% of their body. Not your own hand, it is their hand, because my hands are pretty small, other people might have larger hands. Inhalation burns, we're looking for that upper airway burning, throat, mouth, those type of burns. If they're in a house fire, if they're in their exploded meth lab, those type of things need to be reported. The reason it's within the 3 days that you have to make that report is because it's not for criminal activity or investigation. A lot of it has to do with state statistics and information regarding what kind of behaviors and stuff that we have. So a bullet wound, powder burn, or other injury caused by the discharge of a firearm. This needs to be reported. This can be reported to a trooper, whether it's accidental or it's purposeful. Any of those needs to be reported. Knife wounds, not I cut myself cutting onions. We're looking at non-accidental cutting or stabbing. Anything like that needs to be reported. Both the bullet wound and the cutting and stabbing can be done with local police department and troopers. This is for not only statistics, but some sort of investigation of it. This is where you got to get a history of, did they cut themselves accidentally, on purpose, stabbed, tripped and fell, running with scissors, they drop the knife and it lands on their toe. It's been there and done that. And lastly, any injury that possibly caused a death. We report all of these injuries to troopers, so they need to know they can investigate, troopers or any local police department. So remember, second or third degree burns, 5% of the body or more, inhalation burns, bullet wounds, powder burns, any of those firearm wounds, and then non-accidental cutting or stabbing. Do you see spousal abuse on here? Negative. Do you see dog bites on here? Negative. It is not mandatory reporting for those. The reason that spousal abuse and domestic violence is not mandatory is because as long as neither one of them are vulnerable, they are in their rights to make the decision to stay in that kind of situation. Now, once there is a stabbing or a shooting or things like that, that's when it becomes mandatory. Otherwise, you can advise them, but it is not a mandatory report. Here's the different contacts. Vulnerable adults, you can call that number there. There's also pages on the internet, child abuse, phone number. Injury reporting, you can talk to the Alaska State Trooper about the gunshot wound, the stab wound. Burn injuries, there's actually a burn report online. And again, 3 days, 5% of the body or more, or any inhalation burns. So remember those, and if you see something, say something. And the reason why? Don't ask yourself, what if I'm wrong? Ask yourself, what if I'm right? Don't say something and you're like, man, there's something going on. And something was going on and you didn't report it. That's horrible. But if you think something's wrong and you report it and it's deemed unfounded, no harm, no foul, move on. So what if you're right and you don't make that report? Advanced directives. This is basically allowing the person to make a decision for themselves. Patient Self-Determination Act. We will cover DNRs, it covers living wills, and it also covers power of attorney. This is the end of life situations for people. So they determine who's going to be able to take care of them, decisions for what's going to happen when they become incapacitated to make decisions. Here in Alaska, we call it a Comfort 1. It's very similar to a do not resuscitate. What's different is the Comfort 1 allows the person to specify what things they do or do not want attempted during their resuscitation. It could be a bracelet that they're wearing. So when you look over a patient, look for that Comfort 1, get a piece of paperwork, document. When somebody has a Comfort 1 program, a physician fills out the program enrollment, the patient's given a copy of the form and a wallet card at the time of the enrollment of the program. They might want compressions done, but they don't want to be intubated, or they don't want to be defibrillated more than one time. So that's the difference between like a DNR of don't resuscitate as opposed to a Comfort 1. You're allowed to do certain measures. Maybe somebody doesn't want IV medications done during an arrest and just compressions and defibrillation. It really depends on the enrollment of the person and what they've talked to their doctor about. But make sure that you look over patients and see if they have a Comfort 1, or ask them if they're super sick before they go unconscious. Later in the rest of this PowerPoint, we're going to cover medical ethics. I want you to look at this question here, answer it in the medical question back on the classroom. 75-year-old man discharged to hospice care about an hour away. He's close to dying. He's got cancer. He's got different lesions. He is absolutely sick. His daughter confirms a valid DNR and wants the crew to make him as comfortable as possible. So what are the things that we can do? I know at the BLS level there's no medications to be given, but is that something that could be provided? What kind of treatment? Do we give him like medications? Do we put blankets on him? How do we treat him? If you want to go ahead and answer that in the medical board, compare your answers with other students. In the common law of torts, there's two different concepts of negligence. Res ispa liquiter basically turns, in Latin it says the matter speaks for itself. When it's basically clear of whose at fault. You drop a patient and they break their hand during the fall. Loosely translates to the facts speak for themselves, is a rule of evidence that allows the injured parties to bypass the usual proof of negligence in their claim to recover damages. In negligence per se is a doctrine in U.S. law. It's considered negligent because it violates a statute. Negligence and then per se actually stands for by itself or in itself. Essentially, a law was broken. So if you were driving an ambulance or driving to the scene above the legal limit, you've actually violated a law. So the act itself was illegal. Negligence is a legal theory that must be proved before you can hold a person or company legally responsible for the harm you suffered. Proving negligence is required in most claims from accidents or injuries such as car accidents or slip and fall cases, except for the ones previously stated where the victim does not have to prove because the thing speaks for itself or there was an actual violation of law. For negligence claims, you need to prove 4 things in court: duty, breach of duty, damages, and proximate cause. In order to win a negligence case, the plaintiff or the person that was injured must prove the following elements. So duty, the defendant owed a legal duty to the plaintiff under the circumstance. A breach, the defendant breached that legal duty by acting or failing to act in a certain way. Damages, the plaintiff was harmed or injured as a result of those actions. In causation, it was the defendant's actions or inaction that actually caused the plaintiff's injury. So legal duty, medical providers owe a patient a legal duty to provide them with competent medical care. When you do or don't do something that a reasonably prudent person in the situation would have done, then you have breached that duty. Damages requires that the court be able to compensate the plaintiff for his or her injury, usually through monetary compensation like expenses for medical care or property repair. There has to be some sort of either physical damage, psychological damage, or punitive damage. And then the fourth element, the proximate cause, requires that the plaintiff show the defendant's negligence actually caused his or her injury. Someone might be acting negligently, but the plaintiff can only recover if there was some sort of cause and damage to the plaintiff. We do have some protections from negligence, just like the immunity of good faith reporting. We do have some different defenses. To be afforded the protections of Good Samaritan, the medical personnel must not have a pre-existing duty to provide care to that patient. So if you're not on shift and you don't announce yourself as a medical provider, you don't have an existing duty to that that victim or that patient. If you go, and so you don't have to act. Really, the Good Samaritan law doesn't protect us in any other way. It really protects the layperson only if they do what they've been taught and what they think is best. Even if the person dies, they've done what all they can do. Governmental immunity basically stops people from suing the government and government employees and officials in many cases. If you work under a government contract and orders, you are protected from civil lawsuits. Statute of limitations is a law that puts a limit on the amount of time you have to get a case started in civil courts. They basically can't wait until they have an argument with you and you guys are no longer friends before they bring up this lawsuit, like just because they're angry. And contributory negligence. In a pure contributory negligence state, if you have any fault in your own harm or damages where you're alleging any medical malpractice, you are barred from recovering from any of the damages. So the victim cannot participate in their own issues or concerns at the time. Some protection from the liability, something that might help you so you don't have cases of negligence against you. Look good, look professional, look clean. You're less likely to be targeted if you look like you know what you're doing. Standard of care, so study and perform at a good standard of care. Know what you're allowed to do and know your skills. And then you can also get some insurance. Another way to protect you just in case there's some ambulance chasers out there. Many times scenes need to be investigated by law enforcement. Physical evidence must be preserved and left undisturbed to allow a thorough investigation by the responding law enforcement. Obviously, life safety is priority number one. You want to leave paraphernalia at the scene, move the weapon, but do not remove it from the scene. Do not leave any fingerprints on it. If you do touch it, make sure you tell them that you've touched it. Tell the officer where it was found if you did have to move it. It's basically common sense. Do not risk own life for the evidence preservation. It's all about scene safety. If you look at this picture here, there's a huge mess. There's parts and pieces of a car around, so you want to make sure that you clean up your mess, but you leave the evidence in place. Patient care does take precedence, but do not make purposeful mess. Do not stomp around and add a bunch of mud. Make sure you are aware of your surroundings and the situation that you're in. Medical ethics, we're going to cover ethical versus moral. Many times in non-medical situations, ethics is like laws, codes that a community or a culture have. Morals is your upbringing and your personal thoughts on things and what you decide of right and wrong. So medical ethics are the principles of basically a professional conduct. Rights and duties of their selves to provide care to the patient. It's not their feelings, it's not their religion, it's not, I mean, it's the rights and duties that they must perform. Not going off of medical tests that haven't been done or any of those. It is proper professional conduct. You need to respect the 4 primary and equal principles of medical ethics. So autonomy, respect for autonomy acknowledges the right for a competent person to make their decisions free from interference. So we get that with our informed consent. Patients have a right to say what may and may not be done to them. Non-malfeasance, do not harm or injure the patient, either intentionally exposing them to unnecessary risks or through inaction. Above all, do no harm. Beneficence, the act of doing good on behalf of another person or to promote the good of others. More than just non-malfeasance, active actions to promote that good. Good should be defined by the patient. So the doctor knows best does not apply. You take the patient's opinion and their respect of autonomy, and you actually perform something that is good for others. Justice and fairness, a person's right to be treated fairly, often revolve around the fair distribution of health care resources and the fairness of providing health care without prejudice to all members of society. So you cannot treat the accused rapist any different than any other person that has any medical issue that they may have. You have to treat them as if they are just like anybody else. You cannot have any different personal discrimination against them. When there is no definitive right thing, sometimes you must decide the least bad option. Which one can you justify and how will you justify it? Difference may be in the behavior or the motivation. So again, questions in the assignment. See what you have to say, compare it to others. Unresponsive 42-year-old woman with a pulse. Read through this. What should they do? They find a suicide note, as well as a valid DNR. Do you withhold CPR? Do you continue CPR? Because at the time of the suicide, did she have consent? Did she have refusal? Did she have the ability for denying care? But we also have that valid DNR form. So go ahead and make a note in the form. The trolley program. This one is super common in any ethics course. You must decide which switch, if you're going to flip a switch, and why. Should you flip the switch? Compare your answers to others' answers. Switch the trolley up a little bit. Now the trolley's running down a track and cannot be stopped. Do you push the man to stop, or do you allow it to keep going? So it comes down again to what the least bad option is going to be. There's no right or wrong, it's just the least bad. Go ahead and compare your answers to other students' answers. So the principle of double effect. So you may act to help others even if the unintended result of the act results in harm of an innocent. So there is that you may push the man as long as it helps others, but you may not act if the intent is to harm somebody. So you may not push the man. You're not allowed to push the man. So it's the principle of double effect. Which do you do? Which one is right and wrong? So you should have an understanding of each of these terms now. Understand what is required to prove negligence, the duty you have to provide care, and what ramifications if you breach that duty. Best way to protect yourself is to document your justifications for all your actions. Ensure that you have consent. Understand why we need consent, as well as paperwork, documents that might trump over those consents. understand what your legal protections are, as well as infractions that you may face for breaching those. So a Class B misdemeanor is not something that I would want. And understand ethics. Like, there is going to be some tough decisions to make, and being able to protect yourself is, again, through your justifications and document them. It's what's going to protect you. It's part of that professional standard of care. I hope you enjoyed this presentation, and I hope it's got a lot of information for you.